Did the government mishandle this? Why could the government not talk to the Chief Justice of India? Why couldn't there be a conversation? Why has the government chosen the confrontational path? Is this a big mess up in this case? The BJP has a lot to defend tonight, and that's why we have two views from the BJP. Pinky Anand, member of the National Executive and advocate of the Supreme Court. Pinky Anand, welcome back to the program. Satyapal Jain, national head of the legal cell of the BJP. Thank you very much. Abhishek Manu Singhvi, Ariman Sundaram, Congress spokesperson and MP and senior advocate of the Supreme Court. Sanjay Hegde, senior advocate of the Supreme Court, and Abad Ponda is advocate of the Mumbai High Court. So we have different views tonight. Abhishek Manu Singhvi, the government argument is this, Dr. Singhvi. Can you hear me, Dr. Singhvi?
Yes, of course, I can.
Yeah. So the government says, we don't know why Abhishek Manu Singhvi and the Congress party are trying to say we made a mistake. We can't pick up the phone and tell the Chief Justice of India our views. And had we spoken to the Chief Justice of India and told the Chief Justice of India that, with respect to you, sir, we don't agree with the appointment of Gopal Subramanium, and had the Chief Justice of India held his ground and say, I don't agree with you, then the government position would have no locus standi. Reconsideration is part of the consultation process. What is the big fault in what we've done? The government is asking you tonight.
Can I respond, Arnav?
Yes, sir.
Yeah. First of all, don't insult the intelligence of this government, that the government is to come out with such fig leaves of pretenses and excuses. This is the most flippant and puerile set of excuses I can ever think of. The government is unfortunately, and not speaking through the law minister, not speaking officially, but through a series of innuendos, press leaks, etc., suggesting that segregation is a normal thing and that there is no problem.
Yes.
But according to me, the charge is not segregation at all. That is digressing and diverting the issue. There have been, of course, many instances of segregation. The issue is that when evidence amply, indubitably establishes that the segregation was only because I opposed Modi and you therefore, Arnab, segregated me, then this is a direct assault on judicial independence. Now give me half a second more. The only other reasons trotted out are, one, IB report, nobody has heard of it, seen it, a swimming pool allegation where nothing was taken, a tape recording where actually Subramaniam is praised for his integrity and objectivity, and a CBI complaint, no doubt, which was settled many years ago in the public domain, after which the CBI has repeatedly engaged Subramaniam in important cases. So if you take away the fig leaf of these pretenses and excuses, the sole sin committed by Subramaniam is that he had the temerity, and by the way, no self-respecting lawyer, Arnab, will refuse an amicus brief, that he had the temerity to accept an amicus brief and to give his objective views. And last and not the least, Arnab, lastly, there is now evidence in the public domain. A very senior minister of this government and a valued colleague of ours, erstwhile valued colleague of ours, has in the public domain written against Mr. Subramaniam when the case in the Supreme Court, the amicus brief, was taken up. So it is very clear that the view of the BJP about Mr. Subramaniam has been articulated in writing in the public domain more than 2 or 3 years ago. And unfortunately, Arnab, this is the cross-section, intersection of blatant violation of judicial independence coupled with vendetta politics in the sphere of appointment of judges. And lastly, Subramaniam has done a great service to the government by not putting more egg on its face by this completely uncalled for and hasty withdrawal. I think the Chief Justice used the language of studied moderation. He is compelled by his office to use that language, but he has condemned this action of the government. And had Mr. Subramaniam not withdrawn and reiterated his withdrawal, I have no doubt, and the Chief Justice's statement itself makes it clear yesterday, that there would have been a reiteration and a re-endorsement, and then the government would have been scuttling in all corners.
All right. 1 second. So Abhishek Manu Singhvi, you've had your opening remarks. I hope you will, with equal attention, listen to the response of the BJP representatives and the two lawyers who will counter your views. And Ariman Sundaram, I'm coming to you. By the way, this is open debate.
Yeah, I'm pleasantly surprised, Arnav, that you heard me without interruption. Very pleasantly surprised. I hope you keep to your own standards.
So I was listening to you because I was watching with clear and obvious attention to the several inconsistencies of your own argument, which I assure you, Dr. Singhvi, I will point out in the course of the discussion. That's why I was listening to you.
Thank you.
Pinky Anand, your response. Point is, why is your government become so arrogant in 1 month? Why don't you consult the Supreme Court collegium while formulating your own opinion?
Arnab, the procedure which is set down by the pronouncements of the court as well as the interpretation of the constitution is very clear. The collegium recommends, the government is to consider, and the manner of consideration of government incidentally is set down that the IB and the CBI reports are to be considered not only for the appointment of a Supreme Court judge but also vis-a-vis bureaucrats, senior bureaucrats and secretaries, and based upon that recommendation the government can accept it and reject the contention of the collegium, and thereafter the matter has to be sent back to the collegium, and it is for the collegium then to take a final
Then why did you leak stories against Gopal Subramaniam?
Arnab,
tell everyone tonight, why did you leak stories against Gopal Subramaniam?
No,
tell everyone tonight.
We leaked the stories. Arnab, the question is very clear. When you asked on the first instance, let me just conclude on that and I'll come back to this in a moment. The question is of the government's power. First of all, by this entire exercise, what is sought to being said is that the government has no power in this entire process to do or not to do anything. The government has to act.
No, that's not what is being said.
When the collegium recommends, the government should accept blindfoldedly without taking any action
no, absolutely not. No, nobody is saying that.
The constitutional scheme is the president appoints. The president appoints the
nobody's
judges,
saying that.
And that is the manner of appointment.
Okay,
so therefore,
we are opening
the
up
state
to
government
debate.
has done this.
We're open to debate now. We're open to debate. Ariman Sundaram raises his hand. He goes in first. Ariman Sundaram. No. But by the way, I would like to point out the collegium's nomination is forwarded to the government on the 6th of May 2014. On the 28th, the Chief Justice receives the government's opinion. In between these periods, several stories against Gopal Subramaniam are leaked. The Congress party says, why are you leaking information against him? Are you doing this to create a case against him? BJP says, we never leaked the stories. Ariman Sundaram jumping into the debate. Yes, please. Ariman Sundaram.
Arnab, let's just get one thing very clear. The procedure is very, very simple. The Supreme Court sends its recommendations to the government. The government thereafter looks into it, and if they have any comments, if they do not agree with anything, they then send the list back together with their comments. The Supreme Court then considers this, and then after this reconsideration, either reiterates their original recommendation, sends it back to the government, in which case it's binding on the government, or the Supreme Court may accept some of the suggestions made by the government after considering the matter, and may in fact even delete any names from that list. Now this is the procedure. What has been done here is something totally different. The list has been sent to the government. The government has unilaterally segregated without discussion with the court, without discussion with the Chief Justice, has segregated without any such discussion, removed one name and said warrants will be issued for the other three. Now what has been done is one very vital link. If they had an objection, they should have sent the list back and said, look, we have an objection to this name, the other three are fine, please reconsider. And the court could have either sent back all four names or three names or done what it wanted. This is the procedure. Why was this procedure departed from? It is my view that over the years, the Supreme Court has become a very, very powerful body. There have been complaints that the Supreme Court is coming into policy matters and is interfering with government action. I believe that this was an aim of the government to try to very subtly say that, look here, we are going to exert our rights. And I do not think the people in government are so naive that they were unaware of the procedure. They were so naive that it was, a mere procedural lapse. I think it was a very deliberate aim to say, look here, we as government are also not so happy with the earlier judgment which gives the primacy to the Supreme Court. We should be involved.
No, you see the argument being made. I see Sanjay Hegde's hand go up there. Satyapal Jain wants to come in as well. The argument being put here is very, very clear now. This is a tough battle. A new government with a huge majority feels it is very powerful and very empowered. And there is a feeling that we need to put the judiciary in its place. Sanjay Hegde, I see you are wanting to come into the debate. So, there is no consultation between May 6th, the date when the collegium forwards names to the executive, including that of Gopal Subramaniam, and May 28th, when the executive's decision to question and segregate Gopal Subramaniam is placed before the collegium. What Aryaman Sundaram says is this,
Let's get one
that
thing
this
clear.
government is wanting to pick a fight with the judiciary. Yes, Sanjay Hegde.
Let's
That
get
it's a
one
tough
thing clear.
battle.
The Supreme Court made one recommendation of 4 names. It did not make 4 recommendations of 4 separate names. So if you disagreed with the Supreme Court's one recommendation, then you sent back the recommendation and said, this part of the recommendation we have a problem with. This is a new government. This is a government with a huge majority. I don't want to go into the question of whether it was getting into a turf battle or anything. It lacked constitutional vision.
No, why don't you?
It treated this appointment, yes, it treated this appointment like the appointment of a minister's personal secretary. No, you will not have this man. They've done it in the bureaucracy. They treated this file just like that and said, no, this man, we have a problem. These 3, we are sending it across to the president. Let the appointments go through. That is not how constitutional functionaries behave. That is not how constitutions work. You work in an atmosphere of consensus. That the dialogue process is not one way, but the dialogue must be a sustained and polite process.
But why was there no dialogue, Satyapal Jain? Tell me, why was there no dialogue?
Mr. Arnab, the position, legal position is very, very clear, and I am very sorry to say that unnecessary imputations have been attributed to the government about the confrontation with the judiciary and all that. The Supreme Court Collegium proposed 4 names to the government for consideration for making appointment against 4 vacancies in the Honorable Supreme Court. The government has no problem with so far as the 3 persons are concerned. There is some reservation, some material against the 4th proposed nominee by the Honorable Supreme Court.
No, what material? You don't show the material.
Just give me 1 minute.
You impute the material.
Give me 1 minute. Just give me
You plant stories about the material, and Gopal Subramaniam says the only reason is because I put Amit Shah in the dock.
That is what
Pinky Anand that you don't want to
the
answer.
basis on which the 3 judges were recommended
Let us forget what Gopal Subramaniam says. The giving of the material is visualized even by the Supreme Court in the 9 judges bench judgment which I am having before me. And if you permit me, just I'll read 3 lines from the Supreme Court 9 judges bench. This says, the Chief Justice of India is not entitled to act solely in his individual capacity without consultation with other judges of the Supreme Court in respect of materials and information conveyed by the Government of India for non-appointment of a judge recommended for appointment. This is visualized by even the 9 judges bench that in certain case government may have certain reservation. The material is being supplied back by the Government of India to the Supreme Court, and as per this 9 judges bench, it is all collegium which will sit together.
1 minute, let me also point your attention. Let me also bring your attention, since you bring in one case. 1 second.
His name.
No, 1 second. Let me bring your attention to the case, and I want Abad Ponda to come in. Abad Ponda, by the way, welcome to the Newshour. Your first appearance on the program. Feel free to come into the debate. This is an open debate right now. I'm not going to be tossing around. Feel free to come to the debate. The question is, in the October 6, 1993 judgment in the Supreme Court's Advocate on Record Association versus Union of India case, Supreme Court categorically states that the executive may have its say, but the ultimate decision lies with the Chief Justice of India and the collegium after due consideration of the executive's views. So, just to take the other argument, what are we blaming the government for? Had Gopal Subramaniam stood his ground, not taken back his candidature, and the Chief Justice of India backed that, Gopal Subramaniam would have become a Supreme Court judge even if the government felt there were problems with him. So the government's views were not binding on the Supreme Court. It's the other way around.
Arnav, I think what has happened is very unfortunate. Normally, honorable judges of the High Court who are Chief Justices are elevated to the Supreme Court of India. But in this case, considering Mr. Gopal Subramaniam's eminence, his standing, his integrity, honesty and capability, he was sought to be an able candidate to be made a Supreme Court judge by the collegium and the Chief Justice. Now, you are absolutely right when you say that as per the 94 judgment of the Supreme Court, though the President signs the warrant, it requires ordinarily the consensus of the Chief Justice and the other judges of the collegium. But ultimately, the government's decision is never binding on the collegium. The government's decision is only one which is recommendatory in nature. Now, what has happened here, instead of criticizing everybody, one must understand the problem we face. The problem is getting confounded because Mr. Gopal Subramanium, who's an extremely honest and a man with great integrity, has felt singled out. Unfortunately, this took place when the Supreme Court was on vacation. And when the Supreme Court was on vacation, the Honorable Chief Justice was abroad. He felt nobody is speaking up for him, and Mr. Subramaniam has obviously felt singled out. And he has gone and said that I am really not interested in something where people are criticizing me. If Mr. Subramaniam had just waited for a few days, as Justice Lodha said, then necessarily things may have been different. But even now, I don't think the situation is out of hand. In my submission, the collegium is not obliged to accept his withdrawal. They can always persuade him to see that he doesn't withdraw, because ultimately the casualty is the cause of justice. We are losing an extremely good person who would be an asset to the Supreme Court and to the judiciary in this country. One doesn't realize that by this kind of an approach, what is happening is by saying the man has given up and it's singled out, it doesn't end, the problem doesn't end. This is going to set a precedent in future to a conflict between the executive and the judiciary appointment of judges of the Supreme Court, which is a very serious matter and can't be just simply sidestepped by saying that the gentleman concerned has chosen to step down. Why has the gentleman chosen to step down? The gentleman is an extremely upright person who does not want to involve himself in controversy and feels that it is better for him to step down. Whether he has taken the right decision or not is not the question. The question is, why did he take this decision? And this decision is taken in the interest of justice, in interest of everyone to see that the person does not want to show that I'm giving up a lucrative practice, ultimately be criticized. Mr. Subramaniam is an extremely competent lawyer with a very lucrative practice.
Mr. Ponda, there are two political issues here. One, yes, Abhishek Singhvi, coming back to you, there are two issues here. One, political turf battle between government and judiciary. Is there one? Point number two, I think Abhishek Manu Singhvi should show facts tonight to link the decision of the government to Gopal Subramaniam's position on Amit Shah. Or Abhishek Manu Singhvi should, on behalf of the Congress party, take that back and say that Gopal Subramaniam also has no business surmising that it is because of his position of Amit Shah that the BJP-led government is victimizing him. Mr. Singhvi, would you produce some proof to draw those links, or is it just guesswork on your behalf?
I'll immediately answer your question, but I want to first say that for a person so outstandingly suitable to be a Supreme Court judge as Gopal Subramaniam, I have no hesitation in saying he made a Himalayan blunder in withdrawing. Because he could have withdrawn today as we speak, he could have withdrawn day after, he could have withdrawn next week. Withdrawal was always open to him. He didn't give a fair chance to the collegium. And the Chief Justice almost made it crystal clear just yesterday that had that chance been given, the collegium would have reiterated. Now, that's a Himalayan blunder. I am very pleasantly surprised with the new angle given by the previous speaker, whom I don't know, but I think it's a very, very good comment. Quite frankly, I don't think it will happen, but the spirit of what she says should lead the collegium to reiterate nevertheless. Although personally, as a lawyer, I know it's impossible. Personally, I think that the simple technical argument that you can't force a person to be a judge who refuses to be a judge. But I think the majesty of the system can and should be upheld by sending that signal very clearly.
By doing what?
I appreciate this somewhat what he has just said, the previous speaker, that despite the refusal of Gopal Subramaniam to withdraw his withdrawal, the Chief Justice and the collegium re-endorses it after informally persuading him and saying that no, we stand by our original recommendation.
You want a state of conflict, don't you, between the government and the court? That's what you want, Dr. Singhvi.
Please.
You are playing politics in this.
You are sensationalizing, Arnab. You are sensationalizing. This is a suggestion. This is a suggestion from the previous speaker, not from me. I am endorsing it. I think I am adding, in fairness, it will not happen. It cannot happen because of a simple objection that the collegium cannot force an unwilling person to be a judge. But I am telling you that the spirit of the system requires it to be done, because this is an unfair rejection of an outstanding candidate.
Pinky Anand.
As far as the other thing is concerned, can I answer your other question?
When you have
let her respond to this one. We'll come back to the second.
and
Let him respond. Next one will come back to the second.
collegium for whatever reasons best
you
known
asked
to
an
him,
important question.
then
Let me
can
finish
the
that.
process
Very
compel
quickly.
him to come forward in this fashion as you suggest? And is it nothing short than a conflict which you are proposing between the executive and the judiciary? Today
No,
the system
I'm saying that
happens
it's
to be
unlikely to
in
happen.
fact very
I'm
clear
saying-
and divided.
I'm saying the
to the
Chief
extent
Justice-
that you have the judiciary, the collegium recommend, you have the government consider, and the matter go back to the collegium. By this process whereby a particular person says, I don't want to become a judge, you are trying to bring into system only one of conflict to say there is a conflict between the executive and the judiciary, and look, this is what the Congress had
Ms.
not done,
Pinky
and this is
Anand,
what
you
the
are
BJP
only
has done.
repeating what I have myself said. You are only repeating what I am saying myself, that after the Chief Justice yesterday's statement is unlikely to do it. Because he is said so.
No, I'm
that
very glad that you agree that this is not
he couldn't
possible
persuade him.
and this should not be
I am
done. If
only
that be the
saying
case, then we don't
that
need to argue any further.
That this is such a gross case that the spirit of what the previous speaker said must be understood. Now I am on a different
Dr.
point. Let
Singhvi,
me answer Arnab's
why is it a gross case?
Arnab,
Why is it a gross case when a government
It's a gross
exercises
case.
its power and its options? As much as the UPA government has considered and exercised its options in this entire procedure which has been set down by the constitution as
I'll tell you
interpreted
why.
by the court, where the government
tell you
has
why.
a decisive role in this entire process, do you want to take away the government's
I'll tell you
role?
why
You say
immediately.
government has no role.
Sorry,
I'll tell you why
No,
immediately.
no.
Neither
I'd like to.
The government.
I'd like to remind-
Arnab.
No, Dr. Singhvi,
The
I've heard you and
government
I find that there are
has neither on
several
facts nor in
inconsistencies.
law excised the procedure.
Sir, I'll
The
tell you,
government is
sir, the
neither on
Chief-
fact nor in law.
Sir, 1 minute. The Chief
The
Justice
law
of
has
India
been
has...
told to you just now by Mr. Sundaram, and the facts are known that the reason was the sole sin of Mr. Subramaniam in appearing as amicus. Now,
Dr.
therefore,
Singhvi, you would be
neither
very
in fact
happy to
nor
bring
law is the
about any
procedure
such reason
applied.
which would create a
Segregation
conflict.
is well known. This is not a
Would
case
you
of
say the
segregation.
other people's names who've been
This is a
recommended
case-
have any allegiance to the government? Or would you say they are not independent? What would you say about the
That
other
is a very
whose
typical
names have been
digressive,
recommended?
diverting
This
argument.
entire 2 plus
You
2
are now
makes 6,
digressing to
6
other
plus 2
people.
makes
Please answer
12.
Mr. Subramaniam's
Where does
point.
this entire logic come from?
Sir, I'd like to point the attention, and Aryaman Sundaram has been
Please
named
stick to
here.
Mr.
Let him come in.
Subramaniam.
I want to point out here that even Justice Satasivam, when he was the Chief Justice of India, said that the government is part of the consultative process. He even said that the inputs of the law ministry and agencies like the Intelligence Bureau are taken into consideration before a decision is made. So since the government is part of the consultative process, it has put its view forward. And it is up to the Supreme Court to accept or reject it. Now, I don't understand, Dr. Singhvi, unless today you only want to make a political point, why are you
May I
crying
just ask
yourself
one
hoarse
question to Mr.
over interference
May I
with
just ask
judicial
one
independence? And yes, your
It's obvious. It's
question
obvious
from Satyapal
that you are being the
Gentry.
devil's advocate, Arnab.
Mr. Manu
Because
Abhishek
no,
Singhvi,
it's very simple.
can I
It's a
put you just
5-second
one
issue.
question?
The issue
Is this
that
part
they are
is
fully part of the
for the
consultative
first
process
time?
to the
Is it for
limited
the first
extent
time
of
that
sending
Government of
the
India
whole
has
list
sent
back with
any
their
case for
objection?
reconsideration?
They have
Or
not done
such
it.
things have been happening earlier also? Is it for the first
They've
time?
never
Number
done
two,
it.
you must be aware of one case where the Supreme Court quashed the appointment of a High Court judge. And the Justice Kuldeep Singh in his judgment, which is reported in 1992, said, we are surprised as to how did many things which ultimately they found were sufficient to quash the appointment of a High Court judge, Mr. Shrivastava. You must be aware of that judgment 1992. Even after the consultation, the Supreme Court found that the person appointed was not qualified to be a judge. These things have been happening earlier also. Why are you objecting for the first time? And the way Congress party is pleading the case of Mr. Gopal Subramaniam, I think you are yourself spoiling his whole case.
Arnab,
Mr.
Dr. Singh,
you need
Dr.
a little
Singh,
bit of law here. You need a little bit of law here.
If I can,
Two very
if I
quick
can be
points.
heard, Arnab.
Please don't
Arnab,
get
if I can be heard.
It's ridiculous to cite Srivastav's case, or as lawyers understand, a person who is not qualified in that he is less than the age prescribed, or has done less than the number of years to be an advocate, if his name is proposed as a judge, there is a writ of quo warranto which lies, which means that he is not qualified. As far as the consultative process is concerned, please don't interrupt me for a minute, please don't interrupt me. The joint consultative process is of course there to the limited extent that the Government of India can send the whole list back.
Sir.
They never send the whole list back.
Sir.
Therefore the joint
No, is
consultative
your only
process has
objection
been
that the
violated
list
by
was
the Government of India.
segregated?
Sir,
It's the only objection
I
that the
feel
list was
tonight,
separated.
I feel
And
tonight, and Dr.
Had
Singh,
the
you
Government
asked
of
me
India
why am I
sent the
listening
entire
to you
file
with so much
back,
keenness.
then you would have pointed out that why are you not making other 3 appointments? Why are you delaying the whole panel? Then this would have been the argument against the Government of India that you want to withhold
Complete
the
misunderstanding of the
entire
process.
Today Abhishek Manu
The Supreme
Singhvi has
Court makes
painted
the
himself
appointment.
into a corner. I'll tell you why. Because Abhishek Manu Singhvi, in my view, has painted himself into a corner. I'm saying this, I have deep personal, professional respect for his abilities. My question here is, he says segregation is not an issue. The Chief Justice of India's grouse is the segregation of files. But consider this, and I'm putting this to Aryaman Sundaram
I can't help
first.
it if
In the case of Justice C.K. Prasad
Totally
in 2009, the Supreme Court collegium had forwarded the names of Justice Swatantra Kumar and C.K. Prasad to the government. Government returned the file pertaining to C.K. Prasad. I don't know the rules, whereas Swatantra Kumar's file was forwarded for appointment. Wasn't that segregation? Of course it was segregation. Do I know why the government returned that file? I don't know. Your government also expressed a view in the Justice Dinakaran case when you returned his file back to the collegium, citing allegations of land encroachment after it had nominated him for the post of a Supreme Court judge in December 2009. Ultimately, Aryaman Sundaram, it is for the Supreme Court to decide what is to be done and weigh the credibility of the government's view.
May I just add one thing? It's not a waiting list starting from 1, 2, 3, 4. These are the 4 recommendations against 4 separate vacancies.
Can I finish what I'm saying, or would the other gentleman like to finish? Look, Arnab, there is absolutely no doubt that the government has every right, and I would go further, has a duty to give its view on the matter. There is absolutely no doubt about that. But there is a well laid down procedure which is to be followed. Now here, if you decide to say, I am going to segregate, in that I am disapproving X, I approve the others, and I'm sending them on for the warrants to be issued without even a consultative process for such segregation with the Chief Justice. I feel that is erroneous. And why was that done? All that needed to have been... Allow me to finish, please. Allow me to finish. Allow me to finish. Allow me to finish.
Is there any process which requires consultation to happen?
Excuse me, just let me finish. Now, the point here is a very, very simple issue. You have a list of names. You have an objection to a given name. Whatever your objections may be, it may be well-founded, may not be. Send it back to the Chief Justice and say, look, we have a problem with this particular name. Not segregate it, leak the news to the media, come out with why you're not approving X, Y, Z. All this comes out in the media. The Supreme Court, the Chief Justice is not in the country. All this is done. Why? Why? What for? Why create this unnecessary, unseemly situation? All that needed to have been done was it could have been very subtly done. And that is why I started by saying it is a flexing of muscles by the government.
By September, 5, 6 more vacancies are arising in the Supreme Court. The Supreme Court strength would have been reduced practically to half had the government not recommended all these 3 recommenders and nominees.
No, one sec. Satyapal Jain, be practical tonight. What viewers want to know is what really is the government's immense problem with Gopal Subramaniam? A, that they refuse to interact with the Supreme Court collegium. B, all this is done when the court is on vacation. C, there are a series of reports all sourced in some way or the other to the government because it is Intelligence Bureau reports, etc., etc. And it is pushed through, explanations not given. Now you want us to believe, Satyapal Jain, this is not because Gopal Subramaniam was against Amit Shah.
No.
You expect people to believe it is not because of that.
May I clarify
do you agree, Mr. Satyapal Jain, do you agree that your government has behaved in an unnatural manner? Okay, you are the right process, but you have an unnatural keenness to keep Gopal Subramaniam out.
No.
Would you at least admit that and then tell me what is the basis of that?
My government has behaved in a fashion in which it could do, it should do, and it has done. It has only some reservations, some reports about one of the nominees. It has approved all the 3 and sent back the 4th for reconsideration.
Have any of the other 3 been amicus curiae in the Amit Shah case?
Knowing it very well.
He is the only one who has been amicus curiae in the Amit Shah case.
Was the Solicitor General in the UPA regime.
There is no requirement of sending all the 4 back. If we have no objection against the other 3.
I don't know why this theory cannot be intertwined around him too.
Earlier also, if out of the 2 you approve 1, you send the appointee for signing the warrant of appointment to the President.
Sir, please be logical.
And if some clarification is needed,
sir, please be logical.
My government has sent back for reconsideration as required by 9 judges bench of the Supreme Court.
Sir, please be logical and have some sympathy for me tonight.
It's not because of any of his cases.
Have some sympathy for me tonight. Sandwiched on the program between 6 eminent lawyers. I'm trying to be devil's advocate with 6 lawyers, 3 on either side. Consider the timeline of events. The collegium's nominations forwarded to the government on May 6th. It is around the middle of June when the file is still with the executive that we see the CBI's findings being leaked. Then we find findings of another IB report being leaked. Then we see the CJI receive the government's opinion coming to Sanjay Hegde on June 8th. Why should I, Sanjay Hegde, not believe that these leaks and findings are clearly motivated to create a controversy over Gopal Subramaniam's appointment? That's all.
Arnab, what were the leaks required for?
These leaks were clearly
to create a controversy over a man who otherwise has a good reputation.
That Gopal Subramaniam withdrew. Can I be heard, Pinky? Can I be heard, Pinky? The question was that you do not like Gopal Subramaniam. You did not want to communicate to the government that you found him unacceptable, and consequently you adopted the sneaky behavior of continually having IB leaks saying that he is so and so, he is so and so, he does Sanjay, this, that and the other. Where is a man to endure all this? How is he to know that tomorrow you will not say Sanjay, he beats his wife, he does this or he does something else? Or is it simply the holier statement made?
Mr. Hegde,
this is not a process of consultation with the judiciary. This was a process of demonizing a candidate. That is where I join issue with this government.
And before the Supreme Court considers, he withdraws his name. That is the end of the matter.
Which it has done. So where is the requirement which you are adding in this one step in the middle of everything to say there must be consultation by the government before the government sends back the file to the collegium, with the collegium prior to sending it back? How many times do you expect this entire process to be done, and why is it for the first time this is being voiced in this particular fashion in this particular case?
No,
Secondly,
that is because the collegium made one recommendation of 4 names.
The files did come up during vacation
split
period.
the collegium's recommendation. Who are you? You are not part of the collegium.
The collegium sent it in the middle of May. Sorry?
Pinky, the government is not part of the collegium. The collegium has to be consulted. The collegium made a recommendation. If the government had a problem with that recommendation,
let us get a proposition very
clear. It was one recommendation of 4 names. If the government had a problem with that recommendation,
it back to the collegium.
It had to come back to the collegium.
By any standard, nor was it intended.
So what are you suggesting? Are you suggesting that even before sending back the case to the collegium, the government must first consult the collegium, then send back the case to the collegium? I don't know what are you talking.
There can't be a conversation. Show me a rule book which says there can't be a conversation where the government has a conversation with the Chief Justice of India.
If you have a problem with the collegium's recommendation of 4 names, it is not up to you to unilaterally act and say
breakdown of communication.
We will split your recommendation.
One second.
The issue is segregation should not have been done without the Chief Justice being in the know.
So you realize the
without the Chief Justice being brought into confidence, the segregation ought not to have been done.
Proposition of saying there must be consultation before, there must be consultation after. Where is the case?
That is not what is being said.
Consulted the government prior to sending the names?
That is not what is being said. What is being said is, before you should keep the Chief Justice in the loop when you are planning a segregation.
Exactly.
You are making a segregation
keep the government in the loop before the names were
with
sent.
your comment. You are doing a unilateral segregation.
How many will you add on?
That must be done by keeping the Chief Justice
in the loop. And when segregation happened earlier,
otherwise, what you're basically saying is, look, we are a separate entity, you are a separate entity, we have a right, we will exercise our rights. That is not how the different wings of government are to function.
1 minute. You see the consequence of this.
It is very good to advise.
For the news of viewers tonight. I want to go back to Mr. Abad Ponda.
Are you suggesting that all the appointments will not be made? Every appointment will be made.
So that is not the suggestion, but I want to know, is there something called telephones, faxes, emails, SMSs? Can you pick up the phone and tell the Chief Justice of India, this is not about buying ice cream. This is a serious matter about the appointment of a Supreme Court judge. So my question is, Abad Ponda, if it is a serious matter, do you think the government can't communicate with the Chief Justice and say that these are our apprehensions? And then the Chief Justice can give his point of view and you can consensually arrive at some kind of a conclusion.
To the Chief Justice.
Arnab, also before you segregate, You should keep the Chief Justice in the loop. You cannot unilaterally segregate.
You cannot.
No, that is not the requirement.
No. You are
telephone
Oh, you can do anything as the government. The government can try to do anything. The fact is, what is the purpose of it? Unless you're going to lead to a conflict.
When the Chief Justice
I'm coming to you, Dr. Singhvi.
Why have a process? Just have telephone
conflict.
conversations between the collegium and the
Why
state
has
government
this
and the
conflict been
government,
created?
and let it be by means of
Is it a
telephone
turf war?
conversations.
And
This
tomorrow
entire
you will say
process
that
which
by
we are
telephoning,
discussing should
the
be sent.
executive is trying to influence the decision of the Supreme Court.
No, you can have a conversation. You want to have a breakdown of communication? You want to be in a state of war?
See the correspondence between
You want to break faith between institutions?
What does that mean? It means
There
that
is
there is a
absolutely no
recommendation by
doubt.
the collegium. It has to be accepted by the
Okay, what's
government.
Abad Ponda,
And the government
please?
can have no say in the matter. Is that the argument that you are trying to
collegium
put forth?
reasserted, reiterated?
There is absolutely no doubt.
So why are we debating this? No, Satyapal Jain, why we are debating this today for what?
There is absolutely
Today
no
the Chief
doubt.
Justice of India says if the independence of the
absolutely
judiciary
no
is put
doubt.
under a doubt or a threat, then I will quit. I mean, this is not even the suggestion that the Chief Justice of India think of quitting is a very, 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 very serious matter. It's not a joke anymore. This is one of the biggest
Arnab,
clashes we have seen
Arnab,
in
there
decades
is
between the
absolutely-
government and the judiciary. Abad Ponda.
Anurav, there is absolutely no doubt that the government can put forth their views to the Supreme Court collegium as well as to the Chief Justice about any reservations that they have about a particular person to be elevated to the Supreme Court. There is absolutely no doubt that they can do so. The problem here is the manner in which it is done. When the Chief Justice is abroad, the method in which this is communicated in the press, and the gentleman concerned has been literally made to feel that he's committed some crime by accepting an amicus brief and taking it to the hilt to the best of his ability. It has led to a very sorry state of affairs where a wrong signal is being sent. Communication in a healthy manner is always wanted in a democracy. But communication which necessarily targets and singles out an individual, rather than having the spirit of communication, is communication more to single out a person because of something that he may have done in his good faith, good belief that he's doing his job correctly, as the Solicitor General then necessarily sends a very bad signal.
Going to the press. Had he not done so, things would not have been complicated to that extent.
You now want to blame Gopal Subramaniam for acting in a hurry also. Okay, Abhishek Manu
He should not
Singhvi.
have gone to the press. He should not have written a letter to the Chief
one
Justice.
thing,
He should have allowed the
Arnab,
procedure to go on and
This is
complete
like
full
blaming
circle.
the victim.
Arnab,
Well, if
can I
you've not
speak?
gone to the press, you've not been embarrassed.
Arnab.
That's what you want. Dr. Singhvi.
Arnab, I think the points are very simple. If we don't want to recognize them, it's up to us. Let the viewers make a choice. There is a legal aspect and there is a factual aspect. The factual context and sequence of events, most of which you have mentioned, is in fact the more important. Please remember one crucial fact. The view of the then opposition and the present ruling party, and one of its most senior persons articulating that view, is in the public domain in a letter officially available, where Mr.
Sir, you're
Subramaniam
imputing
is
motives.
said to be against Mr. Modi. 1 minute now, please let me complete.
You're imputing
This
motives.
happened 3 years ago, that letter. That shows thereafter that the moment Mr. Gopal Subramaniam's name came,
Show me a paper.
Mr. Manu Abhishek Singhvi.
this is the public domain, it's been published in
Show me a
newspapers.
piece of paper which
Mr.
says
Arun
that
Jaitley's
individual
letter.
No, show me a piece of paper. Who's the individual you're talking about? And show me a piece of
It
paper
is
which
your
says that
party which
individual.
was
Mr.
I didn't
Jaitley
know
has
this is
officially written, don't pretend
Show me.
ignorance now, Arnab. Mr.
No,
Jaitley,
but-
just listen to me, please.
But did Mr.
Jaitley has written officially.
Gopal Subramaniam
Can
to
I,
withdraw his-
please, I'm
Did
saying
Mr.
something else.
Jaitley
Please
influence
listen to
the
me.
decision of Gopal Subramaniam to withdraw
I don't know where
his
you're going,
candidature?
Arnab. I'm talking of the North Pole, you're talking of the South Pole. Please
I am
allow me
not.
for half a minute.
I am not. It's Gopal Subramaniam.
I
to
am
withdraw his
saying
candidature.
that Mr. Jaitley, who is one of the senior most persons, 3 years ago, when this case as amicus was done by Gopal Subramaniam, wrote to the then Prime Minister Dr. Manmohan Singh, saying that Gopal harbors an animus against Mr. Modi.
But the Chief
That is on the
Justice of
record in the
India
letter.
himself said
Now
that Gopal Subramaniam.
today, when the Chief Justice Collegium sends a letter,
Sir,
sends a recommendation, that animus comes forth.
Dr. Singhvi, why don't
And
you
this
answer the
whole
question?
series of
Now you're
whispering campaigns
getting
was
speculative.
and
Gopal
May.
Subramaniam and forced him to
Okay.
resign as a Solicitor
I'm talking
General.
about a letter.
Why
You're
don't you
saying
answer that
speculative.
question?
There's a letter.
Why was he forced to resign
Okay,
as
gentlemen.
There's a letter.
Of the Supreme Court.
Okay,
How
now
do
you
you
know
write
what.
letter?
Talking of committed judiciary, not the
Okay.
BJP. And
Okay, now as I wrap up, I'm saying this, the Chief Justice of India himself said that he asked Gopal Subramaniam to reconsider the withdrawal of his nomination, yet Gopal Subramaniam reiterates his decision to opt out. It is not the government that is responsible for the appointment not going ahead, not the judiciary, but Gopal Subramaniam himself. If Gopal Subramaniam has stuck his ground, he would have become a Supreme Court judge. But he has responded to this by the virtue of his own emotions. He feels hurt about this. But I don't know where the story is going to go, but let's follow it up later. I'm short of time. I thank you very much. There's been a really good chat on this subject on the Newshour tonight. Thank you.